our next panel. We have a very distinguished group with us. We will be moving, I'd like to say, from left to right.
Actually, from the right to the left.
From that side to this side.
House left.
Politically right to politically left.
That's correct.
And we have a distinguished group with us here today, so I will we'll just begin with James Burling.
Okay. Well, this is quite an honor to be at the seminar here named after Michael Burger, because Michael Burger has always been one of my heroes, but unfortunately I don't have enough time to go into all the reasons why, so I'm going to skip over that. And we're going to talk about the relationship. If I turn the mic on, you can hear me. So anything that I said about Mike Burger before, just ignore that. Talk about the relationship between the ability of government to control property and the ability of landowners to use their property, and what kind of oversight should there be by government of the ability of government to condition property? And that's the Koontz case, and I'll move on. So I want to begin by talking about a fundamental law of economics, and that is the lower the cost of a commodity, the greater the demand. And this applies with government, because if government can act without cost, it will act early and often. But if costs are imposed, whether those costs are economic, administrative, or legal, then the government is going to act later and less often. And so the question is, by imposing costs on government, can that be too blunt of an instrument? Is that going to be stopping government actions that are good as well as government actions that are bad? Because the fewer there are costs on government actions that are beneficial, perhaps the better. The more costs there are on difficult or bad government decisions, the better. But how do you do that? And how do you define what is a beneficial government action or what's a bad government action? Maybe there's a sliding scale. The more a government action imposes on liberty, the worse it is. The more that a government action provides benefits or increases liberty, the better it is. So a government action that both restricts freedom and confers little in the way of meaningful societal benefit, well, that's one where more government action should be discouraged. But the devil is going to be in the details. When is a program that benefits society? We talk about environmental regulation that protects the fish like the Delta smelt. Does that protect society, or is that hurting the farmers? How do you draw the line? Because one side loses, the other begins, and the government draws those lines. If it can draw those lines without cost, it's going to simply obey the majoritarian impulse, whatever the public wants at the time. We live in a popular democracy. There are certain ways to employ the political process to encourage good government and to discourage bad ones. But in democracy, there are also plenty of ways that the system can be abused. You have the majoritarian impulses, you have the exploitation of the political process by demagogues, you have rent-seeking that goes on all the time in the political process. And so the political process is simply not an abstract government working for our good. The political process is all sorts of forces and attempts to utilize government to get something for ourselves. And that's the kind of process that I think needs some kind of check. The drafters of the Constitution had a particular way of thinking about that. If you look at Federalist 78 and the idea that there should be a judicial check on government action. If you look at the statue of John Marshall out front of this building, you look at, think of Marbury versus Madison. You know that there is a place and time and place for government, for the judiciary to interpose itself in making sure that government is acting properly and constitutionally. When the government is trying to do something for the greater good that impacts on individual liberties, whether that's protecting security against terrorists or protecting the environment against the encroachment of developers who are going to destroy the Bay Area and make it look like LA, if I could paraphrase Michael Berger's 1975 article, then you realize that there has to be somebody neutral looking at this. And the best we can do, somebody neutral looking at these issues, are the courts. It's certainly not a perfect way of dealing with it because courts are sometimes not very neutral at all. But idea of land use permitting. Municipalities and other government bodies certainly cannot be considered neutral because government bodies, local government bodies, federal government agencies, they have many needs. They have the need to protect the environment. They have the need to protect open space because that's politically popular. They have the need to provide lower income housing because that is politically popular. They have the need to do all kinds of things that cost all kinds of money and requires all sorts of land. So the government has many needs. Landowners generally have a very short list of needs, usually one thing. They want to use their property. And because they have this one need and government has many needs, you have a marriage, if you will, of the needy and the needful. And so like manna from heaven, developers provide to government all sorts of commodities, all sorts of money and land that help government achieve its programs because the agencies are over a barrel. The landowners are over a barrel that they need to get these permits. And the government really holds the keys to the development kingdom nowadays, and it can extract a price that is whatever without a court to interpose itself, the price that the government can exact is basically whatever a developer is going to give away without screaming too loudly. So the government essentially becomes a market participant with the landowner as this process goes forward. That if it's going to cost, if a developer can do a development and turn a $100 million profit, and government comes in there and asks for exactions of $99 million, the developer may well exceed because that's the only way he can get forward. He's going to get some kind of profit. And this is turning landowners into something like regulated utilities. The idea that a landowner has the right to do with his or her land what he or she sees fits, as long as there are no external nuisance-like harms, doesn't really comfortably fit with modern notions of regulatory control of land use and modern understandings of what property is, and certainly not the paid-to-play paradigm of modern exactions that we have now. If land use at the sufferance of government is the new coin of the realm, then it's a coin with two sides, and one side is a theoretical understanding of what property rights are, and the other side is a willingness of government to impose its power to achieve its ends. Among modern scholars of property rights, the old common law notions of the Blackstonian common law notions of property are seen somewhat as quaint. The idea of Lord Coke talking about the house of every one is to him as his castle and fortress, as well as for his defense against injury and violence for his repose, or Blackstone saying so great is the regard of property that it will authorize nothing the less violation of it. Well, those are old ideas. And so now we talk about property as being the bundle of sticks. We talk about it being the economy of nature, as Joe Sachs talks about, which essentially means that whatever nature requires, property has to give up. We talk about it being a utilitarian construct that should be reconstructed to accommodate changing societal needs. You talk about property as being a process and not a thing. The idea that we heard earlier today when Morgan talking about property being something we have in our liberties. James Madison talked about that in his essay on property in the National Gazette. Same sort of language. That was the understanding of the founders. But today, property rights are much more amorphous. And this reconceptualization of property enables greater government authority, power, and leverage over the use of the property. If you put a crab in a pot of water and slowly heat it up, the crab isn't going to mind. And most developers, most landowners are willing to be treated like regulated utilities because it just costs too much time and effort to fight these things. A prudent landowner may well decide to accede to an objectionable, unconstitutional condition because he doesn't want to endure years of litigation and the hundreds of thousands of dollars that it takes to challenge one of these things. But some landowners may not be completely rational, and they may represent a triumph of principle over principle, that is, of philosophical principles over the principle of money. And there are words for those sort of irrational landowners, and I like calling them clients. And such clients have prevailed over the government nemesis, and they haven't established an important check on the ability of government to impose all manner of exactions on property owners. Thus, Marilyn and Patrick Nolan fighting the California Coastal Commission over the demand that they give away 1/3 of their property. Not a very rational thing to want to fight about. And Patrick Nolan, the story is, he originally gave away this permit to the Coastal Commission. He signed the permit, giving away 1/3 of their property. He went into the Coastal Commission headquarters and turned it in. But then he read at the paper, he was a city attorney, and he knew you couldn't cite City Hall, no less the California Coastal Commission. He saw that we, Pacific Legal Foundation, had challenged the Coastal Commission and won in a case. He called us up and said, can you take this case? We said, no, you've already signed the permit. It's too late under California law. He went back to the Coastal Commission, said, I think I made a mistake in a permit I gave you today. Yes, I did. He took it back. He tore it up and called us, and you represent me now, and the rest is history. But the point is that otherwise it would not have been a rational thing to do unless he thought he could get free legal counsel from somebody, and eventually he built this house during the course of the litigation. Florence Dolan fighting over the parking lot easement, or the easement that she give up the floodway and build the bike path. That's not a terribly rational thing to do. I mean, what's the big deal of a bike path and giving away a conservation easement? But her husband was a stubborn guy, and he told her his dying wish is, I want you to fight this to the end. And so, of course, she did. Coy Koontz Sr., and then followed by his son, Coy Koontz Jr. In the Koontz case, they could have given up this property and $150,000. He didn't think it penciled out, perhaps, but ultimately, is this the thing you want to fight for 20 years and the case still going on? Who in their right mind wants to litigate a case for 20 years? Well, all the attorneys are, of course, raising their hands and said, yeah, if I'm the attorney. But if you're the individual, if you're the guy, you don't want to be doing that for 20 years. But because these irrational clients have moved forward with these cases, and Dolan was not our client, but the others were, they have basically created the exaction law that we know it today, the catechism. Nolan says you can't you can't demand an exaction unless it's related to the impact caused by the development. Dolan saying that relationship has to be rough proportionality, and the burden is on the government of proof. And of course, Koontz saying, and Koontz saying that this law also applies to exactions of money, not just land. And if you refuse the permit condition and the permit's denied as a result, you still have the ability to go forward. So you'd think this issue has all been taken care of, and I want to use the remainder of my time to talk about some cases that talk about this and the level and the greater deference or lesser deference given to government as the case may be. A number of years ago, Joe Sachs talked about the idea that there should be a distinction between when government acts in its proprietary capacity and its governmental capacity, with more scrutiny when it acts in the proprietary capacity. Those notions, and even Sachs, I think, abandoned them in time. But I think one thing we do see is that when government acts in its kleptocratic capacity, the government receives greater scrutiny than when it simply acts for the common public good. After Koontz, there are some serious unanswered questions, and I'm not going to go into all the details of Koontz. I think some of the later speakers were, and you probably know about those anyway. But one thing is, does this law of exactions, Nolan, Dolan, and now Koontz, does that apply to legislative or adjudicative exactions, or both? And the second question is, can you bring a facial challenge to a exaction under Nolan and Dolan, or does it only have to be as applied? So let me talk to you about several cases that have just come down, and we've had 3 of these cases in the last week. So it's kind of an interesting week, and one is going to be argued before the California Supreme Court sometime in the next year or so. Levin versus San Francisco. In California, there is, according to the California Supreme Court, no constitutional right to go out of the landlord business. Once property is in rentals for residential rental, that property, under our Constitution, you can require that forever. Now, when that decision came down in the 1970s, the legislature wasn't particularly happy about it, and they passed something called the Ellis Act, which said that landowners can go out of business subject to reasonable regulation. So far, so good. Now we have rent control in some cities, like San Francisco, where buildings built before 1979 are subject to rent control. There's a base rent, and that rent, of course, can increase according to the CPI, the Consumer Price Index, but only 60% of the CPI. So every year you become further and further behind. And so there are a number of landowners that would like to get out of the rental business. And under the Ellis Act, they can. So San Francisco became concerned that its tenants under rent-controlled housing were losing out. And they were suffering harm if they were thrown out of their homes by some avaricious landowner or landlord. So they passed a relocation fee requirement that every tenant being removed from a residential rental housing unit is entitled to relocation fees somewhere in the neighborhood now of $5,000. It changes, and if you're disabled, you get more, and there's a whole formula there. But, you know, roughly $5,000. That was challenged, and about a year ago, that was upheld by a California Court of Appeal. Well, landlords aren't happy about that, but, you know, we're in this pot of water, and it's heating up slowly, and we really don't mind or care too much. So San Francisco thought if a little is good, then a whole lot more must be a whole lot better. So they passed a new ordinance saying that if you are being, and this is being applied retroactively, so if you applied under the old law of only $5,000, now this new one is going to be applied, that if you own residential housing, your tenant is entitled to a fee that is equivalent to the difference in the rental value under rent control and the fair market rental value over a 2-year period. So let me give you an example of one of our clients. They charged rent for a downstairs unit of a 2-unit home. They moved into the upstairs when they bought it. They want to move downstairs. They want to have a little more space. And the rent that the tenant is paying is $2,479.67. You care about the cents when you're being caught to 60% of the CPI. The market value for the rent is $7,394.62. Okay? You multiply that by 24 and you come up with $117,000, which is what our clients, Eleventh, have to pay to their downstairs tenant for the privilege of moving into the downstairs unit. Now, you know, you might think that the city of San Francisco would be a little embarrassed by passing an ordinance like that and defending it in court. Fortunately for San Francisco, the city attorney knows no sense of shame. And we sought declaratory and injunctive relief in federal court, and that's how we get around Williamson County, because they're not asking for monetary damages here, in federal court challenging the legislative demand for money. And the court found this was right. The court found that this legislative exaction after Koontz is subject to the Nolan-Dolan analysis, and it said that we could bring this this facial challenge to the ordinance. It was based on particular facts to give these people standing, but it was a facial challenge. And so this is a case that the district court decided last week, and it was a marvelous decision called Levin. You should look it up. It's on our website. But as I said, the city knows no shame. And so this is from a press release that the city issued after the decision. This decision places a new and significant obstacle in front of cities defending development fees and other development approval conditions. The city must now show not only that a property owner's actions cause societal harm, but the owner's actions are the only cause of that harm. If this decision stands, the consequences could be dire for many laws to protect land use and the environment. My hope, says the city attorney, is that the Ninth Circuit will recognize the potentially far-reaching consequences here and decline to upend takings law in this way. So, in other words, by applying Nolan and Dolan to an exaction that represents greed over sanity, we are upending takings law, if only that were the case. We had a case that came down a couple days before this decision called Koontz Coalition. And this is another one of these cases where we recognize that if you are a landowner who wants to develop housing, then you must be in servitude to the city and you must pay for or finance low-income housing. So when the city of Seattle adopted a new expanded regime where there would be in lieu fees for development of market rate housing with the in lieu fees paid to low-income developers. A group of landowners got together and they called themselves the Koontz Coalition. I mean, isn't that cute? And they challenged it under a facial attack to this legislatively applied zoning. And here the court said just the opposite of what happened in 11. They said they cannot bring a facial challenge to this action because under prior Ninth Circuit precedent that you can only bring an as-applied challenge and this is applied to you. So we have two cases that are diametrically opposed. These will be going up to the Ninth Circuit, and maybe in a year or two we can be talking about whether you can bring a facial or an as-applied challenge. The next case I just want to briefly talk about is another case against our friends of the California Coastal Commission. You would think that after Nolan they would have learned that some types of exactions you can't demand. So in this case called Bauman, the Coastal Commission was confronted with three sisters who wanted to improve the family home by repairing it and rebuild a barn that had collapsed. And they were told they could do that if they granted a lateral easement along the coast a mile away from the house. And the Coastal Commission said, well, what's wrong with that? And they were arguing there's procedural issues of the history of the permitting here that I'm not going to get into. But in the decision, the Court of Appeal from California says, here the commission does not argue that the Nolan and Dolan test is met. How could it when it is not? There is no rational nexus, no less rough proportionality between the work on a private residence a mile from the coast and a lateral public access easement. My point of raising that issue is not that it breaks any new ground, but it shows the continuing need for judicial oversight of what agencies are doing. Because if we do not have that judicial oversight, then the Coastal Commission is going to continue to make demands flying in the face of what what the U.S. Supreme Court held in 1987 in Nolan. So you cannot trust the agencies to do what the law requires. You have to have judicial oversight. I also want to talk about CBIA, California Building Industry Association versus San Jose.
Jim.
Oh, am I out of time?
Yeah.
Oh, I'm sorry.
Isn't he?
Okay. Two sentences. This is a inclusionary zoning fee of $122,000 per residential unit that's being imposed. The Court of Appeal said it's okay because it's just simply a zoning ordinance and it's subject to rational basis, scrutiny or no scrutiny at all. And now it's at the California Supreme Court, and we're hoping that the court will use the judiciary, or the court will use its power to oversee what happened before. And I apologize for running over.
It's all very interesting.
I won't rehearse Mike Berger's technical, strategic, or rhetorical prowess. I'll merely say that in over the 20 years I've known Mike, I've respected his personal compassion and integrity, and I'm gratified to be speaking at this conference at which he is honored. This panel has the topic, Balancing Private Property Against Community Rights. And I love titles like this because 15 years ago, I was invited to speak by the Environmental Institute at the University of Georgia to debate, actually. And the topic of the debate was private property rights versus the public interest. And of course, we know that private property creates wealth. Wealth creates an interest in having a more pristine environment. We remember that places like the Soviet Union without private property were not noted for environmental purity, but whatever. Many people just simply have an intuitive notion that private property is contrary to the public interest. And the article I'm writing in connection with this conference has a more nuanced theme, how those with different versions of the public interest regulate or abuse private property rights to achieve their ends. and my title is On Engineering Urban Densification. Some years ago, an urban planner confided in me that his agency always used the term smart growth in public, but among the planners themselves, the term they used was densification. Now, I know densification used to mean Stalin-era apartment buildings in drab Eastern European cities, but now planners think of it as cute high-rise apartments near mass transit with interesting cafes and galleries on the first floor. Suffice it to say, the public isn't convinced. At least since Bob Ellickson's work in the 1970s, we've understood that homogeneous suburban communities used exclusionary zoning to keep out new construction, especially of denser multifamily housing. The result was higher home prices, less congestion, and lower property taxes. That's a good deal, at least for existing residents. But we thought cities were different. There were too many groups of diffuse homeowners and tenants, too many moneyed interests clamoring for development, so the notion was that the so-called urban growth machine would cater to their interests rather than the interest of homeowners. Some recent research, however, disturbs this traditional view. First, Professor Vicky Bean and some colleagues, using a database of 800,000 lots in New York City, concluded that in practice, New York City zoning reflects the desire of homeowners to limit growth and not the interest of developers in having more growth. And of course, as Jim Burling just alluded to, we've heard stories about San Francisco and other high-tech areas having an explosion in housing prices and rents, and many people in those areas have been venting their ire against what they regard as the neo-colonialists who live in San Francisco and commute to Silicon Valley on luxury Google buses. These people are treated as destroying the way of life of San Franciscans. So that's the question of increasing housing prices. Now, the second development is that economists have recently published research which say that these increases in housing costs in cities, largely resulting from onerous restrictions on residential development, drive productive people away from those cities and to areas where their talents are less well utilized. So the result, they say, is that the nation as a whole is poor as a result of this. And I've seen studies which indicate, for instance, that the economic effect of high housing costs results in a potential reduction in output in the United States of between 13% and 18% between 1964 and 2009. We know, of course, that Harvard economist Ed Glazer has written a lot about the fact that the cure for expensive housing is more housing. More housing, and that's what makes it cheaper housing. Okay, so what should be done about the situation? As Charles Haar wrote 60 years ago, quote, "What deference should be given by the courts to solutions to local problems which are reflective of popular sentiment?" And the Supreme Court in Euclid said, great deference, a lot of deference should be given. A century ago, progressive-era planners thought that disinterested experts could improve people's lives through top-down comprehensive plan and zoning regulations. The real estate industry and affluent homeowners applauded that they would have certainty as a result, and zoning has continued to be popular among most people, although often disdained by experts. Now, in the late 20th century, the rigidity of Euclidean zoning was replaced by flexible devices, such as plan unit developments. As a consequence, however, zoning stopped being as of right and started being subject to the subjective requirements of plan commissions and city councils. Increasingly, cities granted density, quote, bonuses, close quote, in exchange for sweeteners supplied by developers, a process that Gerald Caden called zoning for dollars. And Jim, of course, also alluded to that zoning for dollars here earlier. Well, there's a recent paper by my George Mason colleague David Schleicher and NYU professor David Hills called City Replanning, which advocates what I would call neo-progressive top-down densification. And they start out by saying most cities have political machines dominated by one party. So you don't have the competition between parties to do something best for the city as a whole. And the result is you have aldermanic privilege. Each district's alderman says what you can't do or can do in that particular district. And of course, they wind up supporting the NIMBYs who don't want development in their backyard. So they have a solution. But the solution gives me a lot of concern about what will happen with private property rights. They also are concerned about transactions costs of negotiating rezoning of individual parcels. The bargaining for dollars, bargaining for zoning, they say raises up prices, and that's true. And Jim Burling spoke about the cost of government. While Schleicher and Hills would do away with the cost of bargaining by simply having a new set of arbitrary government rules instead, and so it's take it or leave it, no bargaining costs. And so they want to have districts with uniform development rules and explicit price sheets so that if you want to bump up in density from the minimum allowed, you have to pay a certain amount. It's all in the list prices that you receive. They also want to have zoning budgets. So each neighborhood will have a specifically designed scattering of higher density areas and other locally undesirable land uses, and they'll be spread all throughout the city. But of course, all of that is going to be at a councilman level, and it won't represent the interests of individual neighborhoods. And more important, from their perspective, it will be a take it or leave it proposition. The mayor and the plan commission will work all this out. The experts will agree. They will buy off enough interest to get this through. They will present it to city council on a non-amendable take it or leave it basis. And what's the glue holding all this together? It is extra density, permitted developers until the development budget for higher density runs out. Now, they say that if the uniform price sheet sets prices too low, quote, money left on the table might be regarded as distributively unjust, and here's the phrase I love, at least if one presumes that the community is entitled to new value created by the change in the land use status quo. In other words, government owns all of the rights to develop land not theretofore being used.
These are Republicans?
No, my guy's not. No, these are not Republicans. In other words, government owns the right to all new land uses. Now, this was in the United Kingdom's Town and Country Planning Act of 1947. Gideon has written about this. And of course, but at least the Crown provided nominal compensation as a gratuity for owners. This plan doesn't even do that. So this is a response to this so-called need for increased housing. And of course, there are several problems. First, if you buy the theory that zoning is inherently a local matter because different areas should have different traditions, then it may well be that San Francisco should have different values than Houston, and maybe those should be determined on a bottom-up basis and maybe not by the experts. Secondly, another important element of this plan, the city replanning idea, is that once you have these entitlements in place, they become locked in, they become grandfathered, they become, quote, property rights, close quote. That may remind you of Charlie Reicher's The New Property from decades ago. You try to take socially desirable things you want, you call them property. You take existing property, which you don't want, you say it's subject to more regulation. And so they'll do this once, and it will be done, and the bargain will be sticky and can't be unglued. Well, of course, you remember back in the 1920s when comprehensive planning had its beginning, the notion was you do planning, you do it right, it doesn't have to be revisited. It was only a full generation later in the 1950s that you even started getting plan commissions who had this idea that the dynamism in the economy may cause change that occasionally may make us revisit our plans. So this is a lock-in, and the lock-in, of course, is again based on regulatory property. The notion that government creates property and gives it to people, and that's what is protected by law. But regulatory property is a special kind of property, like taxi cab medallions. Regulatory property has value only because the government prohibits other people from doing what the lucky recipients are allowed to do. And here's where the Koontz case comes in, and the subsequent cases that Jim spoke about, like the 11th case. The point is that from earlier on in looking at Justice Scalia's opinion in Nolan and subsequent cases, we get the idea that inevitably, if government has power to charge for bonuses, as Gerald Caden recognized as well, government has every incentive to artificially reduce the base, to reduce the development allowed as of right, and then to charge owners for getting the additional development. So the result would be, for instance, if I have land in San Francisco and I want to build a high-rise to house more people, which if the market is to be believed, will have more quantity and hence reduce prices. I can't do that without buying the rights from the city. In other words, I'm buying the right to develop on my own land. Is this a justifiable police power regulation? Well, if for a certain reason high density is not allowable, I suppose it would be so. But on the other hand, if high density is not allowed because it's inherently wrong, but simply because I haven't paid the city yet, that changes everything. And this becomes, in my mind, the kind of unconstitutional condition that Koontz precisely was aimed at in the long run. And we'll see what the courts do with this, but I think we have a roadmap, at least, for defending property rights in this situation. And my hope is that if these constitutional arguments against this kind of draconian straitjacketing are successful, the result may be that property owners themselves would be allowed to increase density on their land if it's appropriate. That will reduce the cost of housing. That will do away with the governmental middleman in this, and that truly will reduce some transactions cost. Thank you.
How long was supposed to speak? 50?
No.
Shucks.
Don't you dare.
No, I believe in temporal trespass, so I'm going to try and take up Mark's time. Well, thank you. No, thank you very much for having me speak at this conference, and congratulations to you, Michael, for having done so much work in this area for the past 40 years. And my job is, I think, to try to figure out how it is that when you start to look at the exactions questions, you think of it from the ground up. What is striking about virtually all of the decisions and most of the arguments that are made in this area is that they somehow assume that the status quo ante, in which you have such things as environmental easements and environmental mitigation, as unquestioned values, are consistent with the takings clause and are consistent with the notions of private party. It's also very clear that when you start to see whether or not you're going to impose these various questions, nobody seems to ask what I think to be the basic question, which is, are you optimizing social welfare by the use of the eminent domain clause, or are you not? So let's go back first to the theory of the eminent domain clause, then see how it applies to the Nolan case, which I think is paradigmatic, and then see how it applies to the situations in Koontz. The basic problem that one has with respect to property is it's not only immovable, but it also gets in each other's way. And certain times you need to assemble land which cannot be done through voluntary transactions in order to make usable spaces. So that could be whether trying to put together land for a city hall or trying to put together a railroad track. Now, you can do this thing by arbitrary government power, at which point you have no idea whether or not the public use is going to be greater than the private use that it displaces. Or you could do it only with the unanimous consent of every individual whose property is going to be taken under the strong libertarian model, at which point the holdout problem essentially destroys the collective action, even when there's common good. So the constitutional solution for this is that we require the government to pay just compensation. That gets rid of the holdout power on the part of the individuals, and the just compensation at the same time gets rid of the greediness problems on the part of government officials. Because as Jim Burling said, if you can take something at a zero price, you're going to take a lot of it. If you have to pay its market value, you're going to take less. And so, in effect, if you work this particular kind of execution, and you have something which is reasonably decent in terms of the way in which the government organizes and collects taxes, the value in public hands will be greater than the value in private hands. Otherwise, you would not have paid the just compensation. So that all of these particular rules will essentially improve social welfare. If you knock out the compensation requirement, you will find that government will overconsume, and that will give you the same kind of resource distortions that you have when private parties are allowed to take property from other individuals for zero price. So if you think that common thieves or people who ought to be discouraged, you don't want to put the government in the position where they have the same kind of rights. Now, when you had the situation with respect to Nolan, what happened was that there was a lateral easement that went in front of somebody's land. And the question is whether or not this thing should or should not belong in public hand. The correct intellectual inquiry to make in this particular case is as follows. Let the government figure out exactly what that lateral easement is worth to the various citizens, and then what it has to do is to figure out how it's going to pay the compensation that is owed to the landowner if it should take it away. And if they do the calculations correct, and it turns out that the value of the easement as it perceives it is greater than the cost and diminution in value to the owner, it takes and pays, and we get the social improvement. And if it also turns out that the price is not worth paying, then in effect we don't get the easement in question. Now, the government doesn't like to do this, so it's going to try to find a way in which it doesn't have to pay at all. And so what it does is it bundles the permission to build on the one hand with the willingness to sacrifice the easement on the other. And the reason why this is an abject form of capitulation, if it's allowed to go forward, is that the building permit may be worth $100,000 to a fellow, and the easement may only be worth, say, 10. So what the fellow is going to do is to compare the building permit against the easement, and he will always take the more valuable item. This turns out to be the wrong question because it never gets to the issue of whether or not the lateral easement is worth more to the village than it is to the original owner. And you don't have the heads-to-heads, apples-to-apples comparisons. So in each and every case where you find a government bundling the two things together, what they're trying to do is to avoid the fundamental task that the eminent domain clause is designed to achieve, namely to see that when these properties move from private to public hands, there's some kind of overall social increase associated with the operation. And so we should never, ever allow the bundling to take place. This is absolute, this is categorical, it applies in any all situations. Now, when you start turning to a case like Koontz, the problem is even more acute because of the way in which we now start to define property rights. Generally speaking, if you go back to the orthodox theory of the takings clause, it says that private property is defined as a matter of state law, and then what the government does is it imposes its power to take in accordance with the appropriate principle. Now, if you're trying to figure out what private property means, you cannot have two definitions. You cannot say that private property means one thing when the government wants to move in, and private property means another thing when there's disputes between ordinary neighbors. This thoroughly mischievous and confused version of the situation was in fact endorsed by Justice Robert Jackson in a case called Willow River, and it has led to endless amounts of confusion because if in fact you say there are two sets of definitions, it means that your neighbors can't stop you by private rights of action, but since the government always has a more exhaustive and comprehensive set of rights, they can wipe you out. And the entire function of the takings clause, which is to see that the movements from private to public hands are done only when there are social improvements, is essentially ended. So the question you always want to ask in these cases is, before the individuals and the majority get together, what could they do to their particular neighbor? And if it turns out that you've got somebody like Tom Merrill, owns a nice piece of land out there, can the neighbors come along and say, Mr. Merrill, we don't want you to build, so we think we have an environmental easement over your property which can limit you from doing something. Well, there is nothing in the history of Western civilization which remotely resembles the environmental easement in these kinds of cases. Generally speaking, easements have to be created by consensus or by prescription, and in this particular case, it's just created by mere assertion. It is also an easement which is so indefinite that you have no idea of what its particular content is. So if you want to do this, you have to assume and that whenever you call something an environmental easement, it's just an out-and-out case of government taking. What is so appalling about the Koontz case is the one point on which both sides are in agreement, namely that the environmental easement, which then creates the duty of environmental mitigation, is part and parcel of the basic fabric of Anglo-American law. You put things into that particular perspective, then you have exactly the same problem that we heard described with respect to the rent control rules. You own something and now you have to buy it back again at a price which is satisfactory to the government. So the first thing that Justice Alito should have said in his particular opinion is we don't start from that particular point of view. All right, once you start from that point of view, what do? Well, you now have to go back to figure out how the relationships are going to take place between private owners on the one hand and their neighbors and the state on the other. And if you look at Koontz, there's actually a serious problem in this case, which you have to handle. The fellow has about 14 acres of land. He wants to build on a little bit less than 4. It turns out that in order to do this building, he has to boost up the land in one place. There's then a grade going down on the other. And there's no question in my mind that if, in fact, he so constructed the land that he increased the amount of runoff into public waters or into neighbors, that this would be a Rylance and Fletcher-like tort. Anybody who brings, keeps, and collects something on his land, which is likely to do mischief if it escapes, is going to be liable strictly for the consequences thereof. If you can hold people responsible for the damages after they occur, it is perfectly appropriate to say that you're not going to be allowed to go into this thing. We can enjoin you. And so sure enough, Mr. Koontz was actually aware of this, because when he put forward his plan, he says, I'm going to give you a way to make sure that the grading is correct so it doesn't mess up the electric poles down below. And I'm going to make sure that I could cordon off the water so it doesn't pollute or flood the neighbors or the common pools. And it seems to me that so long as he's prepared to do that, then the rest of it is his business. So now if the city comes along and it says, you know, we really like this land as a wetland, what we're going to do is fine. You buy out the development rights and you can have it as your wetland, and now the political process will take hold, because this is all cheap talk. The moment you actually force them to pay for this stuff, all of a sudden they'll back off. Just as in the Lucas case, the moment they had to actually pay for the easement of $500,000 to keep his house from being built, they abandoned the entire enterprise. And that's exactly the way in which you want the system to work. So it's not as though you give people a free pass. It's what you do is follow the following rule on unconstitutional conditions. To the extent that the individual engages something which would be a traditional tort against his neighbor, against the public at large, you condition the permit on the ability to stop that. But to the extent that you wish to go beyond those particular elements, then you have to pay for everything that you want to take. And so when you have these compound cases, it turns out that Mr. Koontz had got it right, and Justice Alito got it wrong. Now the question then is, where do we go from there? Well, if you get the first point wrong, everything else is going to go wrong. And you have this dizzyingly stupid debate over the question as to whether or not the unconstitutional conditions doctrine applies when it comes to the exaction of a fee which would allow you to make improvements somewhere else. And what Justice Kagan said in her dissent is this is just a real estate tax. Not in my book. The whole point about real estate taxes is they are based upon valuation of the property. They're supposed to collect monies for general purposes, and ideally they would be spent in such a way that the proportionate gains from each individual are equal to or greater than the tax which is imposed. And that kind of condition will then expose very responsible governance arrangements, because nobody will vote for a tax where they're in fact going to be left worse off after the taxes are collected and spent than they were if it were never paid. The moment you allow special assessment, then in effect the tax system becomes indefinite, and you get political fight in which what I'm going to do is impose the tax on you for a set of benefits that I turn out to receive. And it's exactly that kind of squabbling over liabilities which creates the same destructive factional game that when you are basically fighting over assets. So what is it that one ought to do? Is you ought to say that you cannot have selective impositions when you're giving general benefits. And then the question you ask, if you do this on a proportionate basis, and what are you going to spend the money on? If you're not going to spend it on anything, then in effect there's no reason to use the exaction fee, because general taxes will always dominate exactions when it comes to the creation of public goods. And what happens in this particular case is it's perfectly apparent, because the exaction fee is going to be used to spend in order to acquire property which is remote and to make repairs which properly appear on the public budget. And so what you're doing in effect is using off-budget financing for special purposes paid by one group of individuals for the benefit of another. So what you therefore do is say, in this case, you don't need to send it back to the Florida court. You don't have to have 15 various tests to figure out what's going on. You say, in effect, that unless you're preventing a nuisance, every exaction that you're making is illegal. And you know what? You can do this. You can tax me $10,000 so long as you pay me just compensation, i.e. $10,000. So that generally speaking, if somebody tries to condemn cash, you know that the situation is crazy, because the only reason why you condemn anything is in order to overcome some kind of a holdout problem. And in these circumstances where all you want to do is to get money, there is no holdout problem. In each and every case, there is perfect dominance of a genuine revenue tax over the ad hoc kind of assessment that's being imposed on this case. Now, once you do that, then the last point that I'll make is that all of these sort of second-tier issues that are raised in Koontz turn out to be irrelevant. So one of the things you have to ask is whether or not you can limit the exaction so it's on the same plot of land to which the development privilege is going. You don't really care about that. If it turns out that you got the right formula, you can't do the exaction unless you're preventing some kind of a wrong. And if it turns out that preventing nuisance costs you more than the land is developed, when developed, it's a good thing that you don't allow the development to take place. But the bargaining games are, to some extent, made better if, in fact, the local government is limited to the amount of exaction by the property in question. But on the other hand, if it has avarice in mind, then, in effect, it must just flat out deny the permit. You don't want to give anybody that kind of discretion. And since you don't know whether or not the big span, you could do anything you want with the money, or the localized requirement is the appropriate one, the appropriate thing to do is to forget about the whole set of distinctions and put it in the form that I've done it. Now, once you do it in this way, this is the final point. By using the price system, by making sure that the property rights are clear, by not allowing the state to come forward and say, well, we just now claim a new right, we're going to stop development, either in the city or in the country, what you do is you finally get rational government. And the point to make about this is every single progressive move on this front is always justified on some fancy theory of social welfare by people who have no idea what social welfare means. And then as you watch the way these systems move, they get worse and worse and worse. And so what happens is, since you have a false diagnosis of what's going on, your judgment is, well, we have to be even more restrictive, have more tight constrictions on affordable housing and everything else. This is the path to destruction. And the only path that will succeed is one towards market liberalization, in which the takings clause is returned to its original function. Thank you.
Well, good afternoon. I'm truly honored to be here amongst so many luminaries and to be here to honor Michael Berger. I am the Mark Poirier, and I am the delegate from the alternate universe of property theory. Although I have to say at the outset that I don't believe there's a solution. As many stupid academics have tried, here's the rule for takings. It is far too complicated and too much is at stake, and I've written about that. That article is called The Virtue of Vagueness in Takings Doctrine, and I will be talking, yes, I can see a question coming already. I want to, I guess, start with about 30 seconds. I spent a number of years, I haven't done a lot of land use planning, certainly lately. I spent 12 years, most of it doing hydro licensing, and that was, here's a river, here are all the stakeholders in the river, and a federal statutory standard of best adapted to comprehensive use of the resource. So what you're doing there is negotiating with everybody and their kayak-loving sister and the Indian tribe, and then trying to put a package together that seems to get energy out of the river without annoying too many people. So maybe my view of property comes from a decade of doing that. But my view is, and this is dedicated to Richard Epstein, this subtitle, why is this right different from all other rights? I've always wanted to write an article with that title. It's a reference to the Seder. Because unlike free speech or travel or some other sort of personal rights, property has resources which we allocate using property, have many stakeholders whose interests need to be honored and are in fact honored not only by nuisance but by background principles and by 100 years of regulation. The problem is how to balance those interests and in particular, how to accommodate for both more general transitions in understanding and for more fine-tuned problems of planning. So have I really gone that fast? I mean, a lot of this we could put under the heading of externalities, but it poses the question of how to manage those in a system where some people have no voices. The article that I included in the materials comes from some thinking about environmental justice and the exclusion of certain kinds of communities from the regulatory process altogether. How do they get a voice? And what they want is not just a voice in the process. They want a right, they want a substantive result, they want access to process, and they want some kind of sense of dignity. I'm not sure how much I will talk about the community's interest in negotiation, but I do want to point out that most people here are framing the question as the private property owner versus the government without any explicit acknowledgement of other stakes that are there, and that for better or worse and working more or less well, regulatory schemes are intended to address. Ultimately, I think the question is going to be not just the remedy under Koontz, which has a huge question mark over it, but what other kinds of solutions are appropriate. I mean, floating out there, of course, is due process, substantive due process. I tend to think that many of the problems, at least potentially, are addressable through administrative law. I teach administrative law too, and what administrative law does is to help coordinate regulation with lots of stakeholders in a way that seems to obey the rule of law. Where am I going with this? Okay, so transitions. In the context of regulation, we have a doctrine which is quite permissive of transitions. This is regulatory takings, Penn Central. There is the Lucas loss of all economic value test. There is a carve-out, in a sense, for Loretto when there is a trespass, and trespass is a pretty clear violation of any ability to control the property. By the way, trespass, in a sense, is what's at stake in Nolan and Dolan because the exactions there involve easements. So one can see Nolan and Dolan is focused on a particular kind of property right. The theory, and it's not, again, it's not just me, but other people, is that as science changes, as understanding to some extent, frankly, as popular will changes, as morals change, slaves were property and then they're not property, and what do you do about that? There needs to be some kind of mechanism to modulate. Some of this takes place over time as interests of the community as a whole and its various components change. But our current doctrine with regard to regulatory takings is lenient as to the government making rules that limit, not as to making rules that transfer, but as to making rules that limit. How does this work in the more fine-tuned areas of land use and environmental, well, particularly local environmental? It's complicated because I think it is often hard to plan, as various other speakers have spoken about. Rigid rules which kind of spelled it all out turned out not to, whether it's trendy, I'm not sure. I suspect the idea was if it worked right, and that's the big if, there would be advantages to flexibility. When you get flexibility, especially at the local level, if it's not visible, you get the potential for coercion. And that, I think, remarkably, might bring me back to Koontz, or to exactions. Prior to Koontz, exactions, I think, were easily understood as a kind of imposition within the unconstitutional takings doctrine in which someone was told that if they wanted to do something, they had to give away something they owned. At least that's in Nolan and Dolan. Koontz is something different, and I'm going to talk about the other holding of the case on which Alito and Kagan agree, which is that nothing was taken. There's a denial of a permit. The holding says, at least some of the time in my view, a denial of a permit rather than granting a permit with property transfer can be a taking, but nothing was taken. How can that be? Well,
The development rights.
the question is, and I see the universe of property this way, there are things the property owner can do as of right. There are things they cannot do as right, and there's an uncertain area in between. The uncertain area, property owners would like to say belongs to them and is taken away from them. Other interests would like to say they have a stake in it which limits the property owner. Consider the wetlands argument in Koontz. Other people within that watershed, as focused through the government, are interested in the flood control, the environmental, the water purification functions. And even though one of the proposed mitigations was off-site, it was not outside of that particular natural service within the community that benefited from it. So in a sense, and there's an argument, I think, in Koontz about whether that was actual wetlands, and if not, what to do about it. Query, is there a way to get an exception? And I don't know how the negotiation on that point worked. But if there is an interest in the natural service which is affecting the community and which is impacted by someone's property, even though the issue is that the natural service flows. To pretend it doesn't is to fetishize boundaries, which happens a lot in environmental law. So you have a negotiation. There's a question from most of the briefs, which I've read, is to whether that negotiation had come to completion. The problem with a denial without any conditions being viewed as a taking or as coercion is you can't tell what happened some of the time. So, and there are other problems with incentives. I've got 5 minutes left. I think I can get my major points out. If what you want, or if what we have structured, is individual negotiation with some potential for coercion, the problem is telling what's coercive from what's not. And if you say a denial is a taking, then you have to figure out why. I think you want to say that denial is coercion, it's unconstitutional. God knows where unconstitutional takings doctrines altogether comes from. We do have, however, another clause in the Constitution, nor shall private property be taken life, liberty, or property be taken without due process of law. So conceptually, because no property is taken, it seems to me the exaction in this case is about due process, substantive due process. Where can we get with that? I wanted to, actually I don't know, it wasn't me, but an article about Koontz from Fennell and Peñalver is in your materials, and it makes an interesting argument about halfway through, which is that much of the concern that exactions doctrine addresses is actually a rule of law problem. They list 8 factors from Lon Fuller: failure to generalize, failure to publicize, excessive use of retroactive legislation, use of rules that are unintelligible. How about that as a description of land use? Use of rules that contradict one another, use of rules that are beyond the power of the authority, changing rules too frequently, and incongruity between what the rule says and what the agency actually does. They say, well, the complaint of developers vis-a-vis negotiations has to do with generality, lack of publicity, instability, lack of congruity. I think it's most of them, frankly. Excessive use of retroactive legislation, use of rules that are unintelligible, and so on. But that suggests that this isn't a property problem, but a kind of administrative law process problem, or, I'm not quite ready to leave you yet, but I'm going to make it on time, that we need to think of one aspect of property as what process is used to renegotiate it. That may be very different from what many people in this room think, but I think that administrative law is the shadow side of property. Anytime you have resources in which many people have stakes, you have to have a way for them to converse. That is not only about reaching a solution, but also, as I said with regard to environmental justice, about giving other stakeholders besides the government access. So the problem, or one kind of problem that might be addressed in relation to post-Koontz solutions, is to review administrative process. Keep in mind that 2 of the 6 justices in the Florida Supreme Court said, this really needs to be on administrative appeal right now. So there was a sense that the problem should be in the state courts as a matter of how the agency had misbehaved. There's certainly room at the margin for federal monitoring. Justice Kennedy, I want to mention him, seems to be a fan of substantive due process. He certainly was in Eastern Enterprises. I think he has been in some other cases. And Kennedy's interesting because I don't see him as a property conservative on the court. I see him as a process man. I actually wrote a little bit about that, mostly in the context of evolving standards around same-sex marriage, but I use property as a comparator. If you look at his Lucas concurrence, he says concepts of what background properties are evolve. If you look at his opinion in Lujan, which is a standing case, but it's about environmental standing, he says those evolve. If you look in Kelo at his, whatever it is, separate opinion or concurring opinion there, he says, I need to look at the process. He may have no idea how it works, but he says this process looks thorough. It involves various levels of the state. So that I think Kennedy would, in some sense, sign on to the notion that when you try to fix a problem with negotiation about property, it's not necessarily about taking, it's about process. So the question, one question is, what is your remedy? And I think we've heard a lot today in sensible questions about what is the remedy for the coercive effect of negotiations, however frequent they are. And I think there are going to be differences about how frequent they are. It's hard for me to see that it's compensation. Maybe there's monetary damages. What the Koontz Supreme Court did, in fact, was throw it back to the state and say, there's no takings damages here. It's up to the state to decide if there is some kind of damages. Well, what are those going to be? Or is the remedy invalidation? If the remedy is invalidation, then I think you get into the question of whether the delay has been improper or proper, which is Tahoe Sierra versus Del Monte Dunes. And as I recall, before I got to the Supreme Court, there was damages for a temporary taking. But it strikes me again that gets back to the question of whether the negotiation was in good faith, whether it was completed. Last point, and I'll stop. Given the uncertainty in Koontz, I think there is currently an undesirable incentive for both sides to negotiate not at all or secretly or unofficially. The problem from the developer side is that if you think you've received some kind of proposal that is arguably coercive, if you walk away, you may benefit in court, depending on how Koontz plays out. So some people think that Koontz creates a disincentive for developers to work things out because they may be able to get compensated, and I think they feel they do that because they feel that that uncertain territory between what they can do and what is prohibited belongs to them. On the other side, the government entity negotiating takes risks when it makes proposals because some of those may turn out to be actionable. So people propose just publish a list if it's not individualized, but a legislative list of options, maybe that protects, or simply say yes or no, don't give any reasons. Well, that's an interesting administrative law question about whether you can do that. But, or use a mediator so you never officially take any position, or get the stakeholders to negotiate so that hopefully things get worked out at least some of the time before the government ever has to take the risk of suggesting conditions. Those also seem to me to mess up the negotiating process. You may very well say the negotiation process is messed up so often that it needs fixed in another way. But I think I'd better stop here, but I've gotten most of my ideas out from the alternate universe of what is going on with property and goods. It's a process decision. Thank you.
Do we have questions?
That's unfair.
Over here? No. Oh, you're pointing here. Well, go ahead.
Oh, yeah, no, I think I want to make some observations about what Mark said in relationship to the process versus the property rights position. One of the things that happens is if you listen to that speech, the just compensation element simply disappears, and you're in a pure administrative state model where you defend a very broad class of stakeholders. You have a pot out there, and then you're trying to play the divide the pot game. We know very well what happens when those games get played, which is the transactions costs consume everything else, so that you get cases like Delmonico Dunes, where essentially you're running 20-year cycles on these things without some sort of an agreement, because there's no, in these kinds of games, there's no unique solution, and every time you think you've got one, somebody can defect and you can start over again. And the point here is not to maximize transactions cost, it's to minimize transactions cost. Negotiations take you in the wrong direction. One of the great mistakes of the concurrence opinions that Justice Kennedy gave in the Eastern Enterprise case is he somehow or other thought that when you move from the takings clause to the due process clause, you would no longer worry about the exaction of money because it wasn't property. But this is, again, sort of an odd distinction to say the least, because just think of the way in which the process works. Suppose it turns out that these characters decide not to pay the money. Well, what's the government going to do? It's going to impose a tax lien on the property in order to collect it. A tax lien is, in fact, a form of property that the government has. And we know from cases like the United States against Armstrong, if the government just simply manipulates liens in its particular favor without just cause, those people whose liens are demoted or dissolved are going to be able to get full compensation. So what you never want to do in this business is to start to fragment the nature and the types of property rights so as to avoid some kind of a theory. Vagueness, which with some people a nice word, is in fact one of the most costly words in the English language. Another term for it is uncertainty, and what the uncertainty then creates is this endless cycle of delay and bargaining costs. The point of the matter that I did was to say that we only want to have negotiations over what value is when there's environmental harm, the minimum condition that you must meet in all cases. And if we think about this seriously, the issue is not how we maximize participation, it's how we minimize stress. Now, there is a serious area for deliberation, which is, if you remember when I spoke about this, I said if we assume that the government had its act together, it could then determine whether or not it was worthwhile to buy the lateral easement. One of the reasons why it's so difficult for governments to determine how to put their act together is the complete discretion that they have in the way in which they structure the various taxes. And since the political process is corrupt on that particular side, you don't necessarily get uniform signals. But you do not correct one intellectual mess or one administrative mess by creating another. What you have to do is to go back seriously to the theory of taxation and try to figure out how it is that you can allow the government to raise maximal revenues with minimum discord, which is the same thing as the takings problem. And how do you do that? Well, if you take a leaf from Justice O'Connor's fine First Amendment opinion, she's as good as that as she's bad on property law. She basically said in speech cases, we have a flat tax in order to avoid abuse without limiting revenue constraints. Well, that's generally what you ought to do in this area. So all the ad hoc property taxes, special exemptions, and other kinds of things cannot be allowed because what they do is they create all sorts of distortions inside the public space. So the difficulties that you see with the public acquisition problems can't be cured by messing up the takings law. You have to fix that problem. Two wrongs only make things worse. The second wrong never corrects the first.
You know, the whole purpose of property rights is to have clear and definitive and defined in advance assignments of who owns what, so people then can exchange things to their mutual benefit. When you start with Penn Central and you start creating prongs and sub-prongs and start creating telemetric epicycles on the nature of property, then it gets so confusing that, of course, we seek recourse in the kind of administrative process that Mark's talking about. But as my mentor, Myers McDougall, once said, to rearrange the piles in the Augean stables is not to cleanse them. What we really have to do, if we're talking about redistributive elements, is to go to the top level possible, which is namely to say, what kind of tax system do we want, as Richard just said, and once you figure that out, you find a way of empowering other people, and then people can negotiate freely over particular entitlements.
Yeah, just on the question of uncertainty, clearly with regard to environmental, I think with regard to land use, there is often an unavoidable uncertainty. And the question, it's not clear what's going to happen when people do stuff. The people who have decisions, if you use pure property rights, may not be informed or they may not care. And afterwards, there are lots of costs, and it's hard to undo. And then you get transaction costs that may be greater than including people in negotiations up front. I also want to suggest again that because my view is that many natural resources, often including land, have many stakeholders. There is a communitarian element to facilitating negotiations. It's messy, it's not perfect, but I think the alternative can, in many cases, be worse.
No, strong disagreement. What you're doing is you're playing the uncertainty card, but you're playing it in the wrong way. That is, we often have private disputes with respect to land use between neighbors where there are uncertain consequences. There are two ways in which you can try and solve that. One is you could use the common law rule, which says you go ahead and develop in whatever fashion you want, but the moment it turns out that you call actual or imminent harms, we're going to shut you down, no questions asked. And what happens is that people then cleanse the Augean stables before they pollute their neighbors, and you have very few harmful interactions. What you're proposing is a system in which every case before anybody does anything, everybody gets to review everything. And the difference is, in that particular case, you shut out not only the bad, but you also shut out the good. You have costs in 1,000 cases instead of one, and you slow down the government. There are ways to handle uncertainty, and what you have to do is to show that the permit process, which completely deviates from all the rules that have been used for centuries over injunctions, is a superior method. That cannot be made. And it's exactly this kind of mistake which tries to say that community values mystically alter the equation when direct regulation comes in that is wrong. The way in which the community is protected is through a strong injunction which allows them to organize their lives in peace. It does not protect itself, but engages in all sorts of aggressive kinds of behaviors when it can intervene very early on in the process and stop everything from taking place unless you buy them off. So uncertainty, in effect, is a strong argument for the common law rules, not for the administrative process.
Hi, I'm sorry to play lawyer here, but
Got a mistake.
the theory of Nolan and Dolan, I thought, was rather clearly anchored to a concept of the eminent domain power and the idea that what was happening in those cases is that the government was engaging in a taking of property that ordinarily would require just compensation, but doing so in the guise of this quid pro quo exaction sort of transfer.
To the bundle, yeah.
But the takings clause is applicable in those cases, I think, because it was an understanding that the underlying exchange involved something that ordinarily would be governed by eminent domain and would require just compensation. When you get to Koontz, then the one thing that all the justices seem to agree upon is that the ordinary taxes are not going to be subject to the takings clause. So Richard and Stephen want to sort of take Koontz and build on top of it this sort of ideal taxation regime, which is going to coincide with the sort of principles that the takings clause reflects.
That's correct.
But the thing that the justices all agreed upon is they're not going to go down that path. They're not going to create an ideal
Shame on them.
tax regime under the
I
takings
mean,
clause.
look, Tom, there's no question that these guys hate generalization and serious theories. Our job is not to give excuses for their wretched intellectual development. It's to decide whether they're right or wrong. And in this case, they are dead wrong.
Well, maybe in
That's
some
the lawyer's
ideal,
answer.
ideal universe they're wrong, but I mean,
Well, that's what they have to do. They have to think from first principles instead of citing their own wretched precedents. And once they do that, they will basically take a rather different view of the world if they do it
okay,
coherently.
that's your vision of how things ought to work.
Yes.
I'm sort of stuck in the world where things are going to work the way they're going to work, and maybe you can nudge them one way or another. So the court is not going to subject taxation to the takings clause or to any kind of takings analysis. And so what you're really talking about is sort of reforming the law of equal protection as it applies to taxes or something like that, which is a project that has even hardly been started. I think the real battleground in Koontz is going to be over whether or not Koontz is limited to in lieu exactions, which are exactions of money that are offered as a substitute for a specific
Yes.
real property transfer, or whether somehow it's going to break free of the unconstitutional conditions moorings in the power of eminent domain and become some kind of freestanding intermediate scrutiny doctrine for
That's right.
financial exactions. My prediction would be that it's going to be limited to in lieu exactions because that is the thing that's anchored to the theory that underlies Nolan and Dolan, which is that this is all about, evasions of the power of eminent domain.
Well, look, property rights also include restrictive covenants, right? And indeed, the modern law says that restrictive covenants and easements, one possessory, one non-possessory, are servitudes covered by the same private law principles. So now, under your theory, what's going to happen when somebody says that the requirement that you have of a setback is in fact a state-imposed restrictive covenant, and in fact, if you now demand that we give a lateral easement in order to get rid of that restriction, can we now exempt every zoning law to a property theory based on restrictive covenants? I think you'd have to say yes, but you know the answer is going to be no. And the reason is that they're unprincipled. And so I agree with you on the prediction, but I don't understand where the normative case comes.
I have problems with the in lieu concept here either. Years ago, Gideon wrote an article called Tennis Anyone, which is a nice article about Ehrlich versus City of Culver City. The notion that either you put artworks in your new building or you have to pay a city a 2% fee in lieu of putting artworks in your new building. And Gideon asked, quite correctly, does this mean that if I put up a building, I'm limiting the space in the city where artwork could otherwise be displayed? I mean, that was a silly concept to begin with, and attaching it as an in lieu fee doesn't make it any more coherent.
Look, I'm going to put it another way. There's no way to do takings law right on a partial equilibrium basis. What happens is private property is our most comprehensive and systematic notion. Takings and taxes are not categorically distinct. So what happens is all these efforts to develop these categories which make the judges feel comfortable with themselves don't work. And it's interesting when you get to the First Amendment area where they actually care about what's going on, all of these distinctions disappear. They don't have one set of rules for takings, another set of rules for regulations, one set of rules for injunctions, another set of rules for fine. What they do is they have a consistent theory, and they do a hell of a lot better there than they do here. And so what's happened is this endless ad hocery, which is this Penn Central legacy, right? Ad hoc solutions is, in fact, the fundamental source of the error. Oh, then you go all the way against them.
You yourself said that power of eminent domain exists to overcome holdout problem.
Yes.
You said that there is no holdout problem in money.
Well, only if, no, but I also said that it's designed to deal with the problem of indefinite rights. And the holdout problem you get is when everybody tries to impose the liability on everybody else, essentially there is no unique solution. It's a common pool problem with respect to liabilities, and we have eminent domain solutions for oil and gas. We have to have them with respect to the way in which debt is allocated. Have to do it. And if we don't do it, then we will get moderate amelioration, but we'll never get total improvement. That was the point of my takings book. That's what you disagreed when you reviewed it. You wanted to be on the sort of, on the part-time basis, and I said, no, you have to go. Once you start down with a coherent theory, you do it. First Amendment law does that, and at least to the extent that it does better. Takings law never tried. And what you do is, in the end, you're going to be a Penn Central ad hoc basis guy if you continue to push on this kind of rhetoric. Yes, you are.
You have a principle theory of the takings clause that says it applies when the government takes or recognizes property.
No, because all these things are property. Money is not property, so if the government announces, Mr. Merrill, we are now charging you $100,000. Well, I mean, if they take all the money out of your banking account, that's not property. Sure it is.
I was going to ask about legislative takings, but if you're following up on this, then...
I see it differently. I think the court's smart enough to see the mess, and it sets the minimum standards. Why aren't you railing at Congress instead of at the United States Supreme Court?
I do. I'm not selective. I'll rail at everybody. I mean, because I think they're bankrupt as well. I mean, the point here is because the courts are inept doesn't excuse Congress from being inept and vice versa. All of them work according to the same theory. The same theory is bad, and so you should attack them all with equal vigor.
You know that that is a quixotic pursuit.
Well, all intellectual work is quixotic.
No, all intellectual
No,
work is not quixotic.
essentially what happens, and
Sometimes you can travel.
No, but what happens is you see a major sort of system difficulties taking place in this country, and your response is to patch this little hole and let this other one get larger. And my view is...
We've been living with this same structure since Pompelli and the Mayor.
No, we've not. Well, Pompelli was...
It's been, if
No.
you look over the cases, essentially the system has been stable. Most of the things that have
No.
happened since Mahon, although exactions is an interesting side case, have just been logical, purely logical extensions.
No, I
of
think
the
that's
Mahon.
just dead wrong.
Okay,
Euclid,
well,
I mean...
then disagree.
I do. Euclid is a massive extension that goes beyond either Pompelli or Mahon, period.
Euclid was not framed as a takings case.
Well, but it is a takings case. I mean, the fact that somebody doesn't call it that, that's what the trial judge did down below. He called it a takings case.
But the opposite strategy doesn't work either, Richard. Not everything is a taking.
All the world's a taking, some of which are justified, some of which have implicit constitution.
So
That's the point about it. When you alter property rights, you've taken
So
them.
to interject here just a little bit, because I hear these arguments, and they're wonderful arguments, but when I go to court,
We don't care about it.
I have to deal with judges who don't.
See, now
No,
you're
I've
on
got
my
to,
side.
when I go to court, I have to deal with judges who don't get any of this, and we have to explain it in the simplest terms possible. And of course, I'd love to have Richard as my expert witness, but it ain't going to happen. It ain't going to
I'll
work,
be
and
disqualified.
more than likely.
Don't pay by the word, I'll tell you.
Pay by the ideas and you'll pay even more.
So my challenge is to take these ideas or these words and to try to get a court to have the basic understanding. And that is very tough because the judges are basically illiterate about property law, property rights, and they're certainly totally illiterate about what any of the professors have talked about today.
So, Jim, you'll be happy that my question is essentially directed to you, although obviously other people may have a view on it. But it's about what's going to happen with legislative exactions. And where do you think that's going? And then also, one thing I was wondering about was whether legislative exactions actually do sound as a due process problem. Because let's say you have an exaction that has no mooring at all there's no nexus. It's like you want to build something, whatever that something is, you got to pay $100,000 to a local charity. Like just something that has got no relationship. The requirement is no relationship to the exaction itself, to the property, to nothing. So it doesn't have nexus, doesn't have proportionality. You can analyze it as property, but isn't it a substantive due process problem as well? So it's sort of two linked questions about legislative exactions.
The first part of the question is, where is this likely to go? I mean, I think if the courts look at this seriously and intellectually properly, they'll go back to the dissent to the denial of cert in the Georgia Parking Authority case, where Justice Thomas and I think it was O'Connor said that there is really no intellectual difference between an exaction that's imposed adjudicatively or legislatively, because despite the fact that the Ehrlich case, California Supreme Court, said that the legislative exactions were open to the full air of sunlight and therefore you're not going to have the oppression. That's just nonsense. You have just as much oppression from legislative bodies, the majoritarian impulse, as you do from adjudicative bodies. So when you're talking about an exaction that's totally unhinged from anything, you look at it in takings or due process. Well, my problem with due process is 2014 is rational basis, meaning no review at all. If you can come up with any idiotic excuse for this at all. And I was telling Robert Thomas earlier today, my first trip to Honolulu, I opened the newspaper and the mayor says, I think for every golf course we should demand $100 million in exactions. So it's exactly your situation, no connection whatsoever. I think I'd much rather look at that in the taking because they're taking your underlying right to develop that golf course, your development of that right of that property. And that's where the taking stems from. If you start only looking at it in due process, whether there's a rational basis for stealing $100 million, of course there's a rational basis for stealing $100 million. I could do a lot of good things for everybody here if I had $100 million. Trust me, I would.
That's why the Kennedy opinion in Eastern Enterprise means it's five guys against as opposed to five guys for. When he made it due process, every subsequent challenge has failed.
You know, you can take legislative versus administrative exactions, or you could try to split the difference by talking about giving credence to comprehensive rezoning, but not giving credence to small-scale rezoning. But the essential difference between exactions and taxes is that taxes should be broad-based, and if they're broad-based, they'll be voted by the people only if, in fact, you get this kind of welfare-improving move that Richard was talking about earlier. When we had the Euclid case, you know, George Sutherland was a believer in substantive due process, but he had this notion of mobs and contagion and revolutions, and was so concerned about that that in a kind of Hobbesian move, he was willing to give power to the government to arbitrarily divide the cities into districts to prevent that. And that is, I think, still the basis of a large part of the judicial mentality here, that if we go back to this notion of looking at property rights, instead of a notion of looking at stakeholder interests, people are going to rebel and we're going to be in trouble.
Our last question, Gideon Kemp.
This is wonderful, and I'm informed and enlightened and amused. But there's one thing that you guys slid over a little too quick. And I am reminded of a line of Herman Wouk in California, and I hear the same story from New York. The great majority of judges are former prosecutors. I scanned the legal papers to see who gets appointed. And we're talking about something like 12, 14, 11 to 1. There's one guy who's in private practice, and everybody else is a former deputy this and assistant that and whatnot. Now, these are people who not only don't know the thing in the great majority of cases, because the sure ticket to election to court in California, which is a not really, it's really an appointed thing, but it has an elective element, is to identify yourself as being a prosecutor. So if you pick up your ballot when you get home, Jim, and you'll find that every one of these bozos identifies himself as a criminal gang prosecutor, because that's the road to wherever they want to get.
And
Now-
developers and criminal gangs are no different.
That's right, exactly. No, you anticipate my next point. Now, there's a tendency on the part of these guys, almost involuntarily, to believe that the people who are litigating against the government are really bad people. Because if they weren't, they wouldn't be disagreeing with the good government that wants to govern them. So, the bottom line of what I'm suggesting is that whatever wonderful system you come up with is going to have to take the form and be reduced to a system of rules that is capable of being rationally administered by, you should pardon the expression, those Herman Wouk's idiots who sit on the bench and who have never seen a case like that in their career.
We are doomed, if that's,
I'm sorry?
if that's true, then we're doomed, because
We are doomed.
to a steady rate of decline. Mediocrity will become the new American exceptionalism.
No, look, you can easily collect cases which contain some of the most outlandish absurdities.
I know.
You know that? And if you are a practicing lawyer, since they don't fit into the grand scheme of things, you know about them, whereas the professors, if you'll pardon me, don't know about them.
Oh, we know.
Now, I will.
We know one big thing. We're hedgehogs, you're foxes.
No, I will give you only one example, and I'm not making it up. There's a rule in eminent domain law which says that business losses, loss of goodwill, are non-compensable.
Yeah.
If you trace it back to its origin, you'll find that it comes from Justice Oliver Wendell Holmes, Jr., the same one,
Yeah.
while he was still on the Massachusetts Supreme Court.
I have it in my book.
And he justified it by saying that business, quote, business is so uncertain in its vicissitudes, unquote, that it plumb can't be valued. That's why we don't do it.
On the other hand, it's bought and sold every day.
It's bought and sold every day. It is taxed. It's divided in divorce, and it's valued in tort cases. Nevertheless, that is the black letter law. So you are, now, Oliver Wendell Holmes was no dummy. He was very smart. But it is common among these guys to search for something, to offer some rational sounding reason for ruling this way or that way, and it has become a judicial culture in this field that they sometimes reach for absurdities. So whatever system you come up with will have to be relatively easy to administer if it is to retain its rationality.
You know, but Holmes was cynical, and he wrote in a letter to his friend Pollack that the question at the end is who's going to be the grabber and who's going to be the grabbee.
Yes, on that principled note, we end.
That's a good place to end. Thank you all very much.
Great. Enjoyed it.
Thank you, Jim.
Well, see, these are the lefties. This is the problem.